So in the previous lesson, what we did was basically introduce the distinction between the civil law on the one hand and the criminal law on the other hand, the main distinction that we tend to look at when looking at the English legal system. With that being said then, let's talk a little bit more about the sources of law that exist in the English legal system. We'll explain where the law comes from fundamentally. And while there are other sources of law that we could explore in this lesson, including, for example, international law, the main ones that we're going to be examining includes legislation, the common law, the law of the European Union, and customs and conventions. Now, there's a little asterisk next to the law of the European Union for obvious reasons, hence why we're going to talk about that and what those implications actually are later on in this lesson. But we're going to begin first then by looking at legislation and the common law. Now, the primary source of law in England and Wales is legislation that is made by Parliament, known as Acts of Parliament or statutes, parliamentary statutes. And Parliament passes quite a lot of legislation each year. We'll talk about the process of parliamentary legislation and parliamentary lawmaking in a future topic. And how it works, how legislation is passed and the implications therein. But generally speaking, laws that are passed by Parliament are formally enacted by the legislative body. They go through the various and necessary stages of approval, including various readings, committee scrutiny, and then when they get to the end, they finally receive royal assent. This is essentially the legislation, the lawmaking process as defined right here, but we'll get into it in more detail in future lessons, as I just mentioned. This is what is known as primary legislation in the English legal system. In addition to being able to pass primary legislation, so for example, the Human Rights Act or the Sexual Offences Act or the Companies Act from 2006, these are all examples of primary pieces of legislation. In addition to that, Parliament can also delegate its lawmaking authority through what is known as secondary legislation, sometimes also referred to as delegated legislation. This is essentially where, embedded within a piece of primary law, a primary statute, there is the mechanisms in place for a secondary or a delegated assembly or a delegated institution to legislate on behalf of Parliament. Examples of this include statutory instruments, as just mentioned. In addition to this, there are things known as orders in council and bylaws. Okay, again, these are all things that we're going to be exploring in more detail in future lessons' time. Delegated legislation essentially is applicable in situations where more detailed rules and regulations are able to be created without requiring a full act of Parliament. This is important in the sense that it is a flexible and efficient way of addressing quick issues and specific issues or even local issues as well, rather than having to necessarily call in Parliament and for them to pass a law which goes through various different stages, a piece of legislation. They can just pass and they can make amendments to rules and regulations on the fly in a much more flexible and efficient way. In addition to the legislative process and to statute law being a major source of law in England and Wales, we also have the common law. The common law is the law which is developed by judges through decisions which are made in court cases. So, for example, when judges decide cases, they often will rely on something known as the doctrine of precedent, which is sometimes described as the principle of stare decisis. What this means is that legal principles are established by previous cases and are then followed in future cases with similar facts. So, where there is a case that has been brought to a court, there will be facts of that case, as you would imagine. And in order to answer the question of who is correct in that particular case, a judge may rely on previous cases and see what the court said back in those previous cases, why the court said what they said in those previous cases. They will do one of three things in that regard at that point. They shall either just apply the doctrine of precedent and say, well, they said this in this previous case from 10 years ago, the facts here apply in the same way, therefore this case is going to be ruled in the same way owing to this precedent. They will reject the precedent. They will say, this case here, highlights the fact that there is a problem with the previous precedent. So the previous precedent is wrong, and this is going to be a new precedent that we're establishing, and this is essentially overruling the previous precedent. Finally, they might look at the previous precedent and say, well, this precedent is still correct. It doesn't apply directly to this case. There might be some additional facts that essentially allow you to alter that precedent, such that you are still relying on maybe some of the basic principles from the previous case, but that you are diverting slightly owing to the distinction in facts. What this does is it ensures predictability and consistency with the law. It makes sense to suggest that if a court rules on a particular issue in the past, that you should also be ruling in that same way. You can't just be ruling out for no reason whatsoever, unless there's a very good reason for you to divert and to divest from that particular precedent and to go in a different direction. Now, when it comes to judicial decisions, the binding part of the decision, sometimes known in international law and in US law as the main holding of the decision, is known in English law as the ratio decidendi, sometimes just abbreviated to the ratio of the case. This is the legal reasoning which forms the basis of the court's decision. This is the main point of the decision. In addition to, this is part of the judgment which is obviously then followed by the lower courts and also future courts in future cases. There is also the ability in these common law decisions for judges to make comments and observations and to just sort of wax lyrical about their judgments. And those might be subsidiary facts which are not essential to the decision, but that are still added on and attached to the decision. These are known as obiter dicta, or sometimes referred to and abbreviated as the obiter of a case. Again, while not binding in the same way that the ratio of a case is binding, they may be persuasive in later cases, and they therefore may actually find their way into the ratio of a case in the future. So before the Brexit referendum and the shenanigans that brought us out of the European Union, European Union law was a significant source of law in the United Kingdom, as well as in England and Wales specifically. It was applicable to the entire UK because the European Union is made up of member states. The UK, the United Kingdom of Great Britain and Northern Ireland, was a member state, not England and Wales. EU regulations had what was known as direct effect. They were directly applicable, meaning that they automatically became part of UK law without needing to be enacted by Parliament. And this was something that was provided for by Parliament with the European Communities Act in 1974 or 1972, I believe. This act essentially was an act that was passed by Parliament which said any law of the European Union that is directly applicable onto the UK will be binding into the UK. So this is the sort of way in which you get around the principle of parliamentary sovereignty, something we will look at in future lessons' time. EU directives, on the other hand, required the implementation through national legislation, but they also had direct effect in certain circumstances as well. Now, the scope of direct effect, whether it be vertical or horizontal, indirect effect, incidental effect, and state liability, these are all beyond the scope of our learning for A-level law. If you decide to go on to study law at university, you will be required, in the UK at least, to study the law of the European Union law, and so you will be required to study this in more detail. So it's slightly beyond the scope of A-level law, but just bear that in mind if you ever want to study law at university and go get yourself a law degree. Since the UK left the EU law no longer applies directly. However, it's still the case that the European Union has a number of laws which are retained in the UK's domestic legal system. This is as applicable by the European Union Withdrawal Act of 2018. This is known as retained EU law, and it continues to obviously influence the legal system unless it is amended and repealed. So basically what the European Union Withdrawal Act does, or one of the things that it does, is it recognizes that because we have been part of the European Union for some 40, 50 years, there is a lot of law, there are a lot of regulations and directives and decisions, as well as ECJ decisions, European Court of Justice decisions, that have become applicable and have sort of woven themselves into the UK's domestic legal system. And so rather than leaving the European Union and getting rid of all of that law, which would probably be impossible to disentangle EU regulations from the broader corpus of the UK, they say that essentially there is a new category which is known as retained EU law, which is still applicable, which is still wide as a source of law in this lesson. Finally, then, there are things known as customs and conventions. Customs are described as traditional practices which have gained a certain degree of legal recognition over time. These are potentially specific to areas or communities and can be called local customs. They form part of the law in the sense that they are long established, often centuries old. They're often quite reasonable and they're often relatively certain. You also see that there are general customs that exist, but they are less common today, even though they can still potentially influence legal principles. Conventions, on the other hand, are what are known as unwritten rules which will guide the behaviour of political institutions rather than be legally binding. This is owing to the fact that the United Kingdom has an uncodified constitution. The constitution is not all written down in one place, like the US Constitution, for example, where you have a single document that is the US Constitution. And one of the things that forms the source of the UK's constitution is this idea of constitutional conventions. They're not legally enforceable, but they are crucial to the functioning of government.